defense attorneys get cases dismissed. In this video, I'm going to explore this very common question that we receive at my firm. One of the first ways that criminal defense attorneys can get cases dismissed is identifying the party that can help our client the most. Typically, this comes in either form of a judge, the prosecutor, or the jury. The way that we're able to fight for our clients and help to get their case dismissed in front of the prosecutor is by doing our own investigation. We work with our own investigator to identify the witnesses, narrative, and evidence that you and your loved ones can inform us about to help show the other side of the story. Unfortunately, in the urgency of law enforcement investigations, oftentimes the power of accusation leads to law enforcement down one road and one road only. We use the power of an investigator and hearing your side of the story to identify other witnesses and other narratives that tell a compelling story of your defense. We use this information to build that story and present it to the prosecutor, a side of the case that they may have never seen or even heard of before. Oftentimes, when we can show the prosecutor other witnesses, other narratives, or conflicting testimony by witnesses they are already aware of, it makes them realize that they have a losing case. Prosecutors know that if a case cannot be resolved by agreement, they must take it to a jury trial and present to a jury beyond a reasonable doubt evidence that you are in fact guilty. When we show prosecutors weaknesses in their case, such as conflicting testimony or an alibi witness or other information to show that you are less culpable than the prosecutor believed, oftentimes we can convince that prosecutor to dismiss your case because they know they cannot win a trial. The second way that we can often fight to have a client's case dismissed is in front of the judge. The way that we do this is by presenting evidence in a hearing typically called a suppression hearing. At this proceeding in front of the court, we filed a motion, obtain witness testimony, and present why something happened that was a violation of your rights. A motion to suppress basically means the court should keep evidence out or suppress, not allow evidence into your jury trial based on some violation of your rights. Oftentimes, this is done by identifying something that law enforcement did during the investigation or during your arrest that was in violation of your rights. We have helped many clients through the suppression process to convince the judge that evidence should be kept out of their case. When the judge decides to dismiss this evidence or keep it out of your case, oftentimes the prosecutors are left with what we discussed a moment ago, the realization that they are missing necessary evidence to prosecute you, and this can result in your case being dismissed. The third and final way that we seek to have cases dismissed is by taking your case to jury trial. The government has the burden, and it is a high one. They must prove beyond a reasonable doubt that you are guilty of the charges that have been presented to the court. We work with you to help build your narrative through our investigator and witnesses in your case to prove your innocence. We do not sit by and just let the government present their case. We fight hard for our clients to ensure that we can present the best narrative possible for your defense. This process helps us to fight for clients at the jury trial phase to convince the jury of your innocence itself. I hope this video has been informational for you or your loved ones about the 3 ways that criminal defense attorneys can fight to have cases dismissed. We are fierce advocates for clients across the state of Oklahoma, and if you or a loved one has been charged or is under investigation for a criminal case, we encourage you to reach out for a free case planning meeting. Please subscribe to our video here for more useful information about criminal defense and cases across Oklahoma.